Hazelwood versus Kuhlmeier in 1988 was a case that involved a free speech claim by student newspaper editors. They complained about the fact that 2 pages of their school newspaper were deleted by the principal because one story had to do with student pregnancy, another story had to do with students whose parents were getting divorced. The Hazelwood case came on the heels of the Tinker case, which had set a general speech protective standard for student free speech. So the student newspaper editors argued in Hazelwood that the principal was not justified in suppressing the stories in the student newspaper because those stories did not cause a material or substantial disruption of the educational process or interfere with the rights of other students. This school newspaper should have been viewed as what the courts call a limited public forum for student speech. As long as the speech is deemed relevant and of interest to students in the school, they should be able to express any viewpoint at all on any topic at all. The school argued the school had not, in fact, created a limited public forum in this circumstance for indiscriminate student expression. If you look at the overall factual context, that this was taking place in a heavily teacher-controlled and principal-controlled environment of a journalism course. That is reasonably viewed not as conveying the students' own ideas, but rather as speaking on behalf of the school. The outcome of the case was to reject the First Amendment arguments of the student newspaper editors and to create a new rule that was a complement to the Tinker rule. And basically the Hazelwood rule is that if certain expression, even if it involves students, if it is reasonably perceived as school-sponsored, endorsed by the school, then the school may restrict that expression as long as the restriction is reasonably designed to promote a legitimate pedagogical concern. The impact of the decision in Hazelwood has been very interesting because it actually involved a factual assumption that was disputed between the justices in that case. Should the school newspaper reasonably be viewed as an expression on the part of the school, or should it reasonably be viewed as the student's own expression? Justice Brennan's dissent pointed out that although the school does have a fair interest in making sure that it is not wrongly seen as sponsoring or endorsing ideas in the newspaper, there are ways that the school could make that clear that are far short of actually deleting or censoring the students' articles. And a number of student newspapers in the wake of this decision did adopt a disclaimer policy, making it absolutely clear that what is in the student newspaper reflects the views of the students and not necessarily the views of the school. State legislatures actually have passed laws saying that as a matter of state law, newspapers that are produced in the public schools should be viewed as and legally constitute organs for the expression of students and are not subject to the editorial or censorial control of and do not represent the viewpoints of the schools themselves.